think we're off and running to number 10.
Hi. Anthony Barbiero for the New York Bus Operators Compensation Trust.
Okay. Are you tired yet? Yeah.
We're now on the last segment of this appeal, and this involves network adjusters making a Me Too motion to preclude expert testimony.
Mhm.
So the only thing I want to bring forward that applies to network is, as did the same as RMPG and the J. Gallagher and Gallagher Bassett, is this. In the first instance, when you look at this record, you have to understand that the court asked for a motion to preclude expert witnesses. Now, as a practicing attorney, you don't have much of a chance of winning that motion when the court, sua sponte, asks for the motion. So when you consider whether or not Judge Emerson exercised her discretion in the network adjusters instance or others, please have that in the forefront of your mind. Judge Emerson narrowed the issues of this case beyond what they really are. This case, as regards network adjusters, involves poor claim management, failure to follow your own procedures, failure to monitor the progression of the claim until it went from a $40,000 claim to a $135,000 claim in 2 years, while they had no adjuster adjusting the claim. So it is not a simple breach of contract case. It's a breach of contract case where the contract says we won't be negligent, and if we are, we will indemnify you. And as far as the other defendants, we will not intentionally harm you, and if we do, we will indemnify you. So for that reason, expert testimony is necessary to go through the network records and identify just how network failed in its obligation to evaluate the injuries. And that's another point. There are medical issues, Justice Ford. I understand departure, medical malpractice. There are medical issues in this case that the jury has to, or the trier of fact has to hear about. What was her condition? What do the medical records show? That failed surgery. What was she able to possibly come back to work in 2006 after her spine was stabilized with rods and because it couldn't be fixed any other way and she was on medication daily? Somebody has to bring that out. I'm saying it here in this hallowed chamber, but I'm not going to be able to say that to the jury. There's an expert that's got to comment on that. So basically, for the reasons we've stated before, and especially in the network case, expert testimony is necessary to fill out the obligations that network faced as those medical conditions escalated. And for that reason, I think the judge abused her discretion. Now, members of the court, I'm about to finish here. I want to take this 10 seconds, 20 seconds to tell you that on December 15th, 1965, I was admitted to practice here. And it's been my privilege to appear before you.
I'm sorry, but you're 65,
Yes.
really?
And it's been my privilege to appear here on a number of occasions. And I was privileged to practice in Nassau County, a county that has a courthouse, an old courthouse, with 2 annexes, which are district courts. And when you try cases in the district court and look out the window to the east wing of the Nassau County Court building, you see, carved in stone, justice, God's idea, man's ideal. This appeal is about justice. That's all I'm going to say.
So much. Well, how do you expect him to argue after that?
With respect to counsel, I will stick to the facts of this, but congratulations on a great career. Robert Whitbeck for the respondent. The issues here, and this issue is much more narrow than the issues that your honors have already heard today, but they do come down to one specific thing that the court has already heard. And the fact is, the cause of action here is a breach of contract, indemnification under the contract, and that's all we're talking about here. And the case law, including from this court in Goodhill, in DeFalco, in Roman, is that expert testimony is only for issues of scientific or technical complexity beyond the ken of the ordinary juror.
So he's arguing that why isn't it appropriate to hear expert testimony on industry standard in the insurance industry? Seems like that's the gravamen of his argument.
So each and every one of the things that counsel just alleged that network did wrong are contractual obligations. He's framing them as industry standards and failure to properly handle or to properly report claims, but all of those things are part of network's contract.
Or to even have a body in the chair to hear the claim, to find out that the claim happened, right? I mean, it's pretty clear from my read of the record that your client dropped the ball here.
Your Honor, with respect, that would be an issue of whether or not they sufficiently breached those contractual obligations. And that
Ultimately, yes.
And certainly that is an issue for the lower court, and certainly a jury might end up eventually finding that. But the point is that is still a contractual issue. Even if your contention is that it was egregiously violated, a jury might eventually find that. That doesn't mean, and that doesn't transform this cause of action to anything other than a breach of contract and a contractual indemnity claim. The only other thing I wanted to mention is, as raised in my brief, there was also a timeliness issue here. Commercial Rules 202.70.13c governs expert disclosure in commercial actions differently than CPLR 3101D. And it's not just a timing requirement. It says that the parties are to schedule disclosure of experts 30 days prior to the end of fact discovery to be completed 4 months thereafter. That was never done here. This fact discovery ended in January of 2022, and nothing about this expert was disclosed until the summary judgment motions 5 months later in May of 2022. Again, this is not just a timing requirement because the commercial division actually allows expert discovery, expert depositions, expert disclosure more meaningfully than just, here, I have an expert. So that violation, which really is
an argument that you knew about the expert because of a related litigation, so it wasn't a surprise.
So, first of all, there is no case law that counsel cited, nor that I'm aware of, that mentioning something in another action that you happen to be a party in imputes some knowledge of it. And certainly we have parties such as the City of New York itself that are parties in different lawsuits that have nothing to do with each other. And just the fact that you happen to be in the room for a different lawsuit where you might have heard something on a court conference isn't expert disclosure. And even if it were considered expert disclosure, again, Rule 202.70.13 requires it to be more than I have an expert. It has the name, the credentials, their prior cases that they've testified in, the compensation they're being paid, all of those things, not just happening to mention it in a court conference.
Okay,
With that, I'll rest on the brief if there are no other questions.
thank you.
Thank you.
Thank you both.
Thank you.